Former Supreme Court Associate Justice Adolfo Azcuna says the Senate's decision to archive the impeachment complaint against Vice President Sara Duterte was a sound move as it allows for future reconsideration. Let's discuss that statement with Justice Azcuna himself, who joins us on Morning Matters today. Magandang umaga po sa inyo.
Magandang umaga po sa inyo din, Gretchen.
Good morning to the author of Forthwith. Okay, Justice, can you explain why you think archiving is a better option than tabling?
Karen, Gretchen, I think the archiving is a good move on the part of the Senate because it does not preclude the Supreme Court from continuing to consider the pending motion for reconsideration filed in the impeachment case by the House of Representatives. Ito po lamang tinabi lang muna just in case the Supreme Court modifies or changes its decision, it can be revived. It is not dismissed. It's not dead. And
Correct.
so it preserves the status quo.
But isn't that the same as tabling in concept? Tinabi lang din muna.
It's not the same as dismissing because the
But
case can
tabling po,
be
tabling.
removed.
Oo.
It's without prejudice to being retrieved from the archives and considered again if necessary.
But how about tabling? What would be the difference between archiving and tabling?
In tabling the matter, Gretchen, it becomes possible to dismiss it still the same the next day. A matter that is tabled is again put on the agenda the following day. So hindi pa tapos. It can be dismissed. Whereas once it is archived, it can no longer be dismissed.
So you don't agree with Senator Tito Soto's statement that he knows for a fact that when it is archived, it is dead?
It is not dead, it's just sleeping to my mind because it can be recovered.
Has the Supreme Court used this word, archive? Is there a proper definition for that, official definition? Or is it arbitrary?
No, not that I know of, but it is a practice on the part of the courts also. In criminal cases, sometimes the judge, for one reason or another, finds that it cannot proceed with the case. It archives it. And in archiving criminal cases, it is subject to being revived on motion of the prosecution within 1 year. If it is not revived within 1 year, then it is dismissed. That's in the courts. So there is an institution of archiving in the courts. And the legislative chambers have their own archiving methods and their own archives and their own rules regarding their archives.
Okay, Justice, what if the Supreme Court, in its decision, operated on the wrong facts? What happens? Does it nullify the whole decision? And has that ever been? Has that mistake been made before by the Supreme Court, where from the basis itself, from the facts that served as grounding for the actual decision, that the Supreme Court got it wrong? And do you think that they could have acted in haste in this situation?
Yes, Gretchen, there have been instances in the past where the Supreme Court revisited its decision and even modified it. And this has been cited by other observers. I remember the Keppel case, the mining case. There have been many cases. The fact is the court, as long as it's not yet final in the sense that the time for motions for reconsideration have passed, it can still be changed by the Supreme Court. So that is the situation now. It is pending motion for reconsideration, and the Supreme Court has the power to change his decision. And even if it's final, executory judgment uh, has been entered, the Supreme Court, in some cases, even modified its decision. Final, already made judgment, may enter of judgment in the Keppel case. Why? Because there is a rule in the rules of court that the court has every power, retains the power to change its decision, even final, in the interests of justice, to prevent a grave miscarriage of justice. Nasa rules of court po yan, anytime, even a final decision. So the court retains the power to change its decision now because it's still subject to motion for reconsideration. And secondly, even if it was final, the court can always revisit any decision in order to prevent a grave miscarriage of justice.
And how often has the Supreme Court overturned its ruling when it voted unanimously on a certain decision? Because that was also a point of argument in the hearings. Sabi nga po ni Senator Marcoleta, saan nyo ba narinig na nag-vote na sila unanimously, na binaliktad pa, and it's most likely not going to happen? Do you recall any case that had a unanimous vote and then they overturned it 180 degrees?
Okay, Gretchen, the former Senate President Tito Soto cited two cases, Bigal Bulaan mining case and another case. I remember one case, the Keppel case, where even after entry of judgment, Supreme Court modified its decision. The point is that the decision of the Supreme Court now is pending a motion for reconsideration. And they don't have to change their votes, but they can modify its effect. There are two ways in which the Supreme Court can still modify the impact of its transcendental decision without changing their votes. One is by applying the doctrine of prospective overruling. That is by saying that our decision today will apply only to future cases, whereas the present case has already been operated under our previous rule, should continue. That's one. Maintaining the same votes. The other is maintaining the same votes. They say that this situation is very unusual. It involves very rare occasions of factual conditions, such that it is not suitable to frame a general law based on these unusual facts. Therefore, we consider this decision as good for this case only. That's what we call pro hac vice. There have been, again, instances where the Supreme Court said that its decision in that case is pro hac vice, in which case it's not binding on future cases. So those are two instances. They don't have to change their votes, but they can change the impact of their votes.
Okay. So I want to go to the second one, which is the ruling for this case only. Could the Supreme Court change the rules for this case only? And say, for example, yun nga po, in this case, it should have given the charges to the accused and also ask for a presentation of evidence to this case only. Isn't that also unfair? Because it based the filing of the impeachment complaint on a previous ruling. I believe that was the Francisco versus HOR case.
Yes, Gretchen. The portion of the decision which requires notice and hearing even on the second mode, that is where Congress itself is the complainant, and it does not, in the Constitution, require notice and hearing. I believe that that portion of the decision now is obiter dicta. That is, it's not a binding portion because it's not necessary to decide the case. The ruling, the ratio of the case now is that the present articles is barred by the 1 year period, and therefore it has no legal existence, and therefore the pronouncement elsewhere in this decision that the articles should have been subjected to notice and hearing first before being sent to the Senate is obiter because it says it does not legally exist. So any further pronouncements on what it should have been subjected to is what we call in law obiter dicta, not binding. So they can say that this is recommendatory only for this case and future cases not binding, but maybe persuasive. That's what will happen if you say pro hac vice.
Okay. Hearing you now, I mean, and hearing your thoughts on how the Supreme Court could correct itself for the future impacts of transcendental ruling, is it safe to say that you don't agree with how the Supreme Court decided?
I respectfully do not agree with all of it. I said maybe they can frame a new definition of initiating proceedings, different from the prevailing definition of Francisco. So that is within their powers. However, to apply it retroactively, I said is unfair. And therefore it should just be applied prospectively because the previous rule or definition came from the court itself. It did not come elsewhere. So the House just followed a definition which was promulgated by the court itself. So unfair to impose a new definition on it now. That is view only, Gretchen. So it's up to the court really to finally decide what is its final ruling on the matter.
Well, a group of lawyers, academics, and citizens led by Justice Antonio Carpio and Conchita Carpio Morales have turned to the Supreme Court to request for a status quo petition, anti-petition. And they wanted oral arguments or an oral hearing of how the process was conducted over at the House before the Supreme Court even decided. But it reiterated that its decision was immediately executory. Do you think there was something strange there? And could an oral hearing be done? Or is it not the usual process, given the complicated nature and I guess the needed clarification of facts?
Yes, the matter of requiring the parties to submit to an oral argument is within the discretion of the court. But since this is a matter of transcendental importance, many quarters, including some former Chief Justice, recommended that there should be an oral argument. And I submit that it's not too late to hold one because the court has the power to order an oral argument on the motion for reconsideration, in which case the House will have a chance to ventilate its side of factual issues, among others, such as what really happened, whether there was a plenary vote or not on the amendment, on the articles that is now the subject of this case. That is the importance of oral arguments, and it is still possible to hold one, and I believe the court is setting the proceedings towards that because it required the other party to comment on the motion for reconsideration. And usually after issues are joined by the motion and the comment to the motion, the court will usually require the parties to submit to either memoranda or oral arguments.
Well, one thing is for sure, Justice, is that there needs to be a clearer set of rules when it comes to impeaching public officials, especially in unusual circumstances, for this not to happen again. But others would argue that the bar has been raised even higher. in terms of what is required to actually impeach a public official. Do you agree with that, na mas mahirap na po ngayon mag-impeach and the Supreme Court's ruling actually gave room for more bogus complaints to be filed? And how would you, if given the chance, recraft the law? That you said na if the Supreme Court were to decide, they should set definite rules on this and apply it prospectively.
The matter of requiring further steps to be taken before the second mode, that is direct filing by the House of Representatives, may be adopted, should be fully ventilated in the oral arguments, so that it will be clear whether or not the court wants it to apply to future cases, or wants the matter to be resolved in a future case where it is necessary to make a ruling. So is it overturned or not? That should be clarified in the oral arguments. To my mind, adding these requirements at this stage of the impeachment would make impeachment unduly difficult and defeat the main purpose of the article, which is accountability of high officials.
Yun nga po, no? Because in the ruling of the SC, they required presentation of evidence, and even that one is difficult to do because kung titingnan nyo nga po, as I said earlier, in the ICC itself, ibang proseso pa po yung presentation of evidence, and there is protection that is needed for the witnesses themselves. So to lay it down on the table of the accused would be a difficult step, right? How do we make this better? To your opinion, when you wrote Article 11, how easy should it be to file an impeachment complaint? And taking a look at what happened over at the House, they had 3 versions of impeachment complaints and one that applied to the 1/3 vote. What room should be given for the House to reconcile different versions to make sure the impeachment complaint is credible?
Yes, Gretchen, I think that that portion of the decision should be revisited, because that will really make impeachment unduly difficult, and besides, to my view, that would be contrary to the Constitution, because the Constitution does not require a hearing on the part of the plenary vote under the second mode, and requiring a hearing under a 7-point procedure would not be constitutional, because that would be intruding on the exclusive power of the House to adopt rules to carry out the provisions on impeachment of the officials and render accountability from them. So, palagay ko dapat tingnan ulit ng ating Supreme Court yung portion na yan.
And finally, where do we go from here? I mean, is the MR just the way to go, to your view, and how does this impact future decisions?
Yes, the very important ruling of the Supreme Court is transcendentally of transcendental impact on not only on the future decisions but on the principle of accountability, which is what this Article 11 is all about. And you know, Gretchen, the rule is you cannot file a criminal case against these high officials without first resorting to impeachment. And therefore, if impeachment is made unduly difficult, there will be no more chance to file even criminal cases, because impeachment is a requirement before you can file criminal cases. So the whole framework of accountability will collapse.
It is the same thing that Congressman Tanyada mentioned, that we must go through the process of impeachment because they are immune from suit while they are in
Correct.
office. And there is no other way to obtain justice than that. So we should protect and safeguard Article 11 of the Constitution. Okay, maraming salamat po sa inyo sa paglilinaw. Marami po kaming natuklasan dito ngayon sa aming programa. We have former Supreme Court Associate Justice Adolfo Azcuna, again, the author of Forthwith, joining us this morning.